Excellent. Thank you for that, Marcus. So let me just do a quick round of introductions. To my immediate left is Marielle Dimsey. Marielle is Secretary General of HKIAC and responsible for its international dispute resolution services from Hong Kong, Seoul, and Shanghai. Prior to that, Marielle was a partner at CMS and co-head of the Global CMS International Arbitration Group. So those of us on Zoom, if you could kindly mute yourselves, that would be great, because I think there's some interference there. She also sits arbitrator, arbitration lawyer, and counsel at the SEAC Secretariat. Prior to joining SEAC, Adriana was a disputes lawyer at leading international law firms in Singapore, where she advised and represented clients in international commercial and ICSID arbitrations. Then we have Sally Harpole. Sally practiced law in Beijing and Hong Kong for over 30 years, specializing in China-related transactions. Since 1989, she has served as arbitrator in international cases that were seated in Europe, Asia, and North America, and administered by numerous institutions, including SEAC, HKIAC, the ICC, and many, many others. She's currently an independent arbitrator based in San Francisco, and I'm also happy to boast that she finds the time to occasionally teach international dispute resolution at UC Hastings as an adjunct professor. So welcome, Sally. And last but not least is Dan Tan. So Dan is principal of Dan Tan Law, a boutique law firm based in New York, San Francisco, and Singapore that has repeatedly been ranked among the top arbitration practices in the world by Global Arbitration Review, or GAR. Chambers and Legal 500 lists Dan as a leading arbitration lawyer. Dan is also a lecturer on law at Harvard and Stanford Law Schools, where he teaches international arbitration and investment law. So the format for today is that each of the panelists will make a brief presentation. And then I think given the level of sophistication we have in the audience, I'm going to try and foster a conversational and interactive session. So please don't hesitate to raise your hands and ask questions. If you're joining us via Zoom and would like to ask a question, raise your Zoom hand. My very talented Deputy Director, Maddie Robertson, will be calling names and keeping the queue for questions. So either raise your Zoom hand or type your question into the chat. The panel will go for about an hour, and then those of us who are in person, there'll be a little reception hour where we can continue the conversation. And finally, let me just make a quick announcement before we start. Those of you who signed up for CLE credit, please do make sure to see Maddie before you leave so you can get your certificate. Yeah. So without further ado, then I'm going to turn it over to Marielle.
Thanks, Hero. Okay, I'm going to try and coordinate this because unfortunately my notes are on my laptop, but we will work this out. Just give me 2 moments. All right, I will. I've never been defeated and been told I was not loud enough before, but I don't want it to start now. So I will do what you did and lean over slightly, and I'm sure this will all be fine. So first of all, thank you very much for the warm welcome I've had here in San Francisco. I was saying to Sally in email correspondence over the weekend, the last time I was here, I was 14 years old, and it was with my school choir from Brisbane, Australia. So it's been a long time between visits, and I'm very, very grateful for how warmly everyone has welcomed us here in what is a very long way from Hong Kong, as I've discovered with my jet lag via Miami over the last week or so. So what I'll be talking about briefly today, and acknowledging also the sophistication of the audience and the fact that a lot of these statistics are readily available on our website. I will give you a brief overview of the HKIAC and its role in Pacific Rim disputes. And then, of course, that will be followed by Adriana's, and then we'll get into the conversation where we would welcome questions on any of the issues, and in particular, the Pacific Rim jurisdictions and the developments recently and what that means for arbitration in the region. So just an overview of Pacific Rim cases from the HKIAC. We've looked at the last 2 years, and we've had, oh, that's gone.
There it is.
Okay, I will hold the microphone. We've had 572 arbitrations administered by the HKIAC in that time, 253 ad hoc arbitrations, and we've done fund holding for 31 cases. So in terms of what Pacific Rim jurisdictions are, and I did have to clarify that with my team before I prepared this, we've taken a very wide view, and we've got about 40 countries here, spanning from Australia to Wallis and Fortuna, and that's in no particular order, and going as far west as Singapore, and of course encompassing the North America and South American continents. So we've had 572 in the last couple of years, and the other two categories that we do track for our statistics is where we are fund holder or hold a role in ad hoc arbitrations under the UNCITRAL rules, and also under the Hong Kong Arbitration Ordinance, which is the procedural law governing arbitration in Hong Kong. We also do fund holding for cases, but as you can see, that's fairly minimal. The total amount in those disputes was 154 billion Hong Kong dollars, and 50.6% of the cases were below 25 million Hong Kong. The reason I've put that up there is because that's the threshold, as some of you may be aware, for our expedited procedures under the HKIAC rules. And this is a push that we're trying to do, similar to other initiatives from other institutions, such as the small claims initiative from ICSID that very recently came out, from the IBA that very recently came out in their report, with the aim being that we will increase efficiency and reduce costs for our users if the expedited procedures are used more frequently. In terms of parties that we're seeing from the Pacific Rim jurisdictions, we've been able to track parties from 22 jurisdictions. The United States is in the top 5. Unfortunately, we have not tracked California-based parties within that demographic, but the United States as a whole is in the top 5 of our parties. Of course, Hong Kong, mainland China, Singapore, South Korea, Taiwan, Australia, Vietnam, New Zealand, the larger jurisdictions that you'd expect from the Pacific Rim region. The types of disputes have been varied, primarily financial and commercial. Corporate commercial are very similar. Professional service, to a lesser extent, maritime, IP, and insurance. The governing laws have been predominantly Hong Kong law, followed by English law, which I'm sure most of you know are very, very similar. PRC law has played a role commensurate with the parties in the particular disputes. We do have California law in there, New York law, New Jersey law, and Cayman Islands law. I should mention with the Cayman Islands, a lot of the cases that track Cayman Islands as in their statistics are often ultimately controlled by a PRC party, but have been structured so that they're in the Cayman Islands. Seat is overwhelmingly Hong Kong. Occasionally we have the PRC, UK, and Russia. Just in terms of Hong Kong and why we're here today, essentially, the Hong Kong has a very pro-arbitration legal framework. I've mentioned the Hong Kong Arbitration Ordinance at the outset. It's very, very closely based on the UNCITRAL Model Law, the 2006 edition, to the extent that most of the UNCITRAL Model Law has just been supplanted into the Arbitration Ordinance, and Ordinance keeping a lot of the provision numbers. We've got a complete protection of confidentiality that's statutorily ensured in Hong Kong. And we have a number of initiatives that come out in the legislature that are then also reflected in our rules. The recent developments have been in the emergency arbitration front, in IP disputes, which have been clarified as being arbitral in Hong Kong, and third-party funding. One that's on the horizon is outcome-related fee schemes, which we hope will be in place by the end of the year. And they're basically going to offer 3 different models, which will now become legal in Hong Kong as a kind of success fee arrangement, which of course is quite common in the United States, but has been taboo in a lot of the other common law jurisdictions for quite a while. And what they will be looking at is conditional fee arrangements, damage-based agreements, and hybrid damages-based agreements. So you've basically got a conditional fee. If you win, you get a certain amount as the lawyer representing the party. That's the CFAs. And if you're looking at the DBAs, you actually get the amount you're entitled to changes depending on the damages or the amount that's actually obtained in the case on the merits. One of our USPs that we like to talk about is the availability of interim relief in the mainland for Hong Kong seated arbitrations. The HKIAC is one of the approved institutions under the so-called Hong Kong PRC interim measures arrangement. That's been added to very recently in 2022 with the additional route under the one-stop shop declared by the Supreme People's Court of China with respect to both interim relief and enforcement. And what this basically means, and I think the interim relief is probably most interesting for this very brief overview, is that if you are party to a Hong Kong seated arbitration, you can, while the arbitration is ongoing, go onshore to the mainland and get interim relief from a mainland court. So namely to preserve assets in a dispute pending the outcome. And Hong Kong, due to its special status in the one country, two systems framework, is the only jurisdiction in the world outside China to whom that is available. So that's something we're seeing being used quite a bit. We actually just got in our 83rd interim measures arrangement since 2019, about 3 days ago. Enforcement of Hong Kong awards. Hong Kong is, through China, a party to the New York Convention. There is also an internal arrangement between China and Hong Kong, which very closely tracks the New York Convention grounds for enforcement of awards. And just as a general sort of judicial point, we have a very strong pro-arbitration judiciary in Hong Kong. The construction and arbitration list is chaired by Mimi Chan, and she's a former Allen & Overy partner, and her judgments are second to none and certainly very robust and arbitration friendly. Just quickly on the interim measures arrangement, this gives you an overview of the courts with which we've had to deal in terms of getting interim relief. We very recently got a judgment from the Beijing court with respect to the preservation of assets, and that's definitely one of the courts we deal with more regularly. But as you can see, there's quite a few courts there that have been invoked under the interim measures arrangement. There we go. And I will be brief now, as I said I would be, and we'll end with a very brief plug for ICA. I'm sure most of you in the room know what that is. It's one of the largest arbitration congresses in the world. It was most recently in Edinburgh a couple of months ago, and Hong Kong has the privilege to host in 2024. And the HKIAC is the host organisation, and we would be very pleased to see everyone there. So on that note, I will conclude and hand over to Adriana.
Mariel. So is it this mic? Let's see. 1 second while I pull up my slides.
Yep.
Okay, there. Well, good evening, everyone. Thank you so much for joining us on a Monday night. I'm so glad to be in San Francisco. Like Mariel, it's been a long time for me since I've been back. So I was just recently appointed as head of America. So this is my first trip to California. So I'm so happy to be here. I would like to thank, of course, UC Hastings for bringing us together alongside CalArb and CLA ADR committee. So actually, I'm curious, how many of you are familiar or have had cases with SIAC or SIAC, as I'm learning it's called here? Oh, okay. There's a lot of you. So, okay, for the benefit of everyone, I'll give a brief background, but I think most of you would be familiar of SIC then. So, well, as most of you would know, we are a very young arbitral institution. So we started in 1991. And in that year, we only received actually 2 cases. But in the 30 years that followed, SIC has grown from a regional institution to now the leading arbitral institution in Asia. And it's now ranked as the #2 arbitral institution only behind ICC, according to the latest Queen Mary University survey. We are headquartered in Singapore. I'm not sure if most of you have visited our Maxwell chambers. So if you have time, please feel free to visit us. And I would plug that next year in August, that would be our Singapore Convention Week. So it would be great to have you there. So apart from Singapore, we have offices in Shanghai and Mumbai and Gift City, Gujarat. And we have in Korea. So most recently, we opened an office in New York at Rockefeller Plaza. We handle essentially any kinds of commercial disputes, and this is a breakdown of the kinds of disputes that we handled last year. So mostly, as you can see on the slide before you, we handled trade, commercial, construction, corporate shipping, but of course, we also handle other things such as IP, IT, banking, labor, entertainment, and so on. Now, numbers, okay. So to a certain degree, an institution's track record can be demonstrated by the number of cases it handles and the sum in dispute of these cases. And so I think that's why, if you notice, most institutions make such a big deal about their numbers. For us, it comes like an announcement of a new Apple product. So we have an event around it just to unveil the numbers, and we do this annually. So what we're seeing is that there is a steady growth of cases coming our way. In the last 5 years, SIC has handled nearly 3,000 cases, and the total sum in dispute in these cases amounted to about $34 billion US. And this involves about 10,000 parties across 100 jurisdictions. So just to quickly share, this is the statistics, at least for this one is collated for 5 years and this one for last year's statistics. And these are the jurisdictions that we've had for the last 5 years. Now, in terms of our geographical coverage, so when SIC, when people hear about SIC, they think it's a very regional or Asian institution, but in fact, we are a very global institution. Last year, 86% of our cases are international in nature. The year before that, it was about 90%. And nearly half of those cases has nothing to do with Singapore. So we're seeing cases between, say, American or European parties, or Latin American or an Asian party. And you'll see on this slide that US is our top 4 user last year. So it did make sense for us to open an office in the Americas, in New York in particular, because US parties have been featuring quite frequently in SIC arbitration. So since 2013, actually, US parties have been in our top 10 users. 2018, it actually topped the list as the #1 user for SIC. This year, it's unofficial yet, but by my count, it would be second. So it's really a competition between myself and the India and China offices. So hopefully, hopefully we get to #1, but it's quite close. Quick statistics of the last 3 years of our US cases. So you'll see there's a healthy amount of US parties arbitrating at SIC involving large sums of dispute. And actually, the total sum in dispute for just California parties alone, I found out recently in the past 3 years, has already amounted to more than 600 million Singapore dollars. And I think that's about 500 million US dollars. These are the types of cases that are being arbitrated before us by US parties. So it's a good spread of commercial, trade, corporate, banking, and so forth. Now, in terms of governing laws, we've seen 21 jurisdictions of governing laws last year, and you'll see on the slide before you there is California and New York, and also in terms of seat for last year, California and New York also featured in our case statistics. Okay, now our global profile is not only seen by our users in our users, but it can also be seen in the people that make up SIC. Sorry, that slide was. So we have a court of arbitration that is headed by Lucy Reed. She is the president right now of the Court of Arbitration. She's based in New York. Immediate past president was Gary Bourne from London. Lucy Reed right now is assisted by 36 eminent arbitration practitioners from all over the world, and some of whom are from the US. So you may be familiar with Nigel Blackaby, Catherine Amirfar, Abby Cohen-Smutney, to name a few. We also have a secretariat that is led by our registrar or secretary general equivalent, Kevin Nash, who is Canadian, and he is assisted by about 18 council from all over the world. They are multilingual and multinational. And you can also see before you, the panel of arbitrators that what we have is quite international. So we have a pool of 500 arbitration practitioners from about 40 jurisdictions. Last year, we made 137 appointments, and out of which 35 came from different jurisdictions. From this, you can see that Americans actually are fourth most appointed arbitration practitioners. So I will pause here for a quick, this is just a quick update of SIC or a preview of SIC. We have some materials outside, so please feel free to pick that up if you're interested. Thank you.
Good evening to all of you who are here present and also those who are here virtually. I want to thank Professor Hiro Aragaki and his team at UC Hastings, along with California Arbitration and CLA for organizing this program. As we focus on what is new, the starting point is that Pacific Rim is already recognized as a top region for international arbitration. Today, we are highlighting the best of the best. I've had excellent personal experiences with both SIAC and the HKIC. The Queen Mary survey, which Adriana mentioned, ranks both Singapore and Hong Kong, as well as the SIAC and the HKIC among the top 5 in the world. Now, North American venues appear in this survey only with New York City in 6th place. There may be reasons for that. University of London's Queen Mary research might be critiqued as Eurocentric. I do credit the centers in Paris and Geneva for their historic role in helping international arbitration a few decades ago to launch as a widely accepted dispute resolution method around the world. But there's plenty going on in North America. And in fact, the statistics of leading arbitral institutions such as the ICC, AAA ICDR reflect that within North America, California is already a very popular venue. I will make some introductory comments on California and hope that we still have time after that, because I would love to talk about Hong Kong and Singapore as it comes together with California. So what are the challenges, opportunities, and developments that lie ahead? The opportunities are compelling, I would say. California has been ranked 5th largest economy in the world for several years. Last month, Bloomberg predicted that California is poised to overtake Germany into the number 4 position worldwide in terms of GDP growth, companies' market value, renewable energy, and others. Renewable energy is the fastest growing business in California. Of course, there's also agriculture, technology, hardware, media, software, and I don't want to leave out the entertainment industry. What we have in California is an enormous number of enterprises engaged in business that is governed by California law. Many of them will prefer to be served by California lawyers, and many require specialized skills and knowledge. I would say that California, by necessity, has a large pool of such legal talent. From a logistical standpoint, California's geographic place makes it the most accessible in the US from Asia. Yes, the flight over the Pacific is long, but it's the first point for a direct nonstop flight from Asia. And this has come up many times in arbitrations that I've handled in North America. It also is a gateway to and from Mexico and Latin America. So California's legislators understand the opportunity for California. And let me be clear, the need for their state to be a venue for international arbitration. They have codified flexible and welcoming legislation for international parties to participate in international arbitration in California. The legal framework for international arbitration in California is similar to what you would find in Singapore and Hong Kong in many ways. California Arbitration, the organization, Gary's here. He can explain much better than I can, but let me just summarize briefly. It was formed to give a voice to the international and ADR community, to be a forum for education and a catalyst for new development. Do follow them and join in if you're interested at calarb.org. Regarding the future for international arbitration, I just want to briefly mention this because it's part of our theme for this evening. The trend for specialized expertise and procedures in arbitration is very likely to continue. It's already started. And here are two examples where I think California holds a unique role in this connection. The Silicon Valley Arbitration and Mediation Center, formed in California, is a recognized base for sourcing professionals with technology expertise, many of whom practice in California, for arbitration support. In the entertainment industry this year, the ICDR announced a panel of arbitrators with entertainment law expertise, many of whom are in California. You will not be surprised. And the ICDR also announced its rules for IFTA arbitration. IFTA is the Independent Film and Television Alliance. And IFTA is now trying to strengthen its approach for international disputes in collaboration with ICDR. California is very much a critical base for this specialized thrust into international arbitration. These are examples where international disputes in industries with specialized legal problems are served by specialized professionals and possibly also specialized rules. I'd love to share more from my long list of factors which favor international arbitration in California, many of which are in common with Singapore and Hong Kong, but I think I'll stop now so that we have time for those free moments. Thank you.
Thanks, Zoe.
Hi, it's great. It's great to be here. So, something that I think was missing from the introductions is that I am Singaporean and I live here. So there are actually two implications flowing from that. Number one, obviously the rest of the panelists are selected because of their expertise. I'm just a token Singapore national on the job. So that's number one. Number two, because I'm here, I'm going to probably talk the least out of everyone, I hope, and that way we'll have more opportunity to interact with our visitors here. I'm just going to talk very quickly about maybe two things. Number one, about a trend, and number two, about a challenge. So perhaps in terms of trends, I'd like to maybe talk a bit about the internationalization of, I think, legal practice. I think when I first started in the US as a young lawyer, being an international lawyer simply means, kind of like sitting behind a big chair in New York and waiting for an international case to be dialed in by your finance partner. That was being an international lawyer. You'd basically work on computers, and then finally that you're hearing in some exotic location, you fly there, and that's basically it. That was what an international lawyer would be. I was fortunate enough to be part of one firm, and I think Steve knows who I'm talking about, where there was this partner who would fly out to China every week. You know who I'm talking about, Steve. He'd be there Monday to Friday and fly back, sort of like on a Friday. And I thought this guy was absolutely crazy. How could he do that? And lo and behold, 15 years later, that's what I'm doing. So these days, I would say, it's no longer kind of like sitting in one place, waiting for a case that's international in nature to come in. I think lawyers these days who practice international arbitration, we're constantly out there, interacting with local lawyers in various firms, as you've seen from the presentation, the SIEC presentation rather. Most of the cases these days, even in very strong seats like Singapore, actually have nothing to do with Singapore at all. So I think that's just kind of like one thing. The other thing which I would say, has internationalized practice a lot is really, I think, the increasing recognition that the enforcement process is a big part of the dispute resolution process as well. So I think most well-advised clients these days would actually, they think quite a bit about, look, it's all good that I have this case, but if I win, how am I going to enforce all these things? So I'd say over the past few years, I've been involved in a lot of multi-jurisdictional enforcement cases, because these days, I think clients are increasingly sophisticated. I think whereas in the past, you might have a company, say, in Indonesia, and basically all you think about is that if I get the award, I'm going to bring this to Jakarta District Court and I'm going to get it enforced, and that's basically it. These days, I think would-be respondents in arbitrations, they have assets all over the place. And so I think a key part of it is the enforcement strategy. So a lot of lawyers who are driving the dispute resolution process, they essentially go out, they contact local lawyers in each of these jurisdictions, and they figure out how to get things done. So I would say, this whole thing is increasingly internationalized to a degree that I don't think we've actually seen before. Maybe just skipping ahead to challenges. I think one challenge that I kind of foresee that might kind of rear its head in the Asia Pacific region is increasing geopolitical tensions, right? So I think for all of you who've read the news, there have been things happening in the world, and some law firms have said, you know what, if you're from that country, I'm no longer going to represent you. So I think about 6 months ago, I get calls practically every other day asking if I would represent somebody. And of course I say, yeah, but we got to check the list to see if the client's there. And sometimes they say, you don't need to check because they're an arms manufacturer. So I'm like, okay, that's useful. But that's something which I think, I think increasingly might be something that we need to think about. The other issue that I see, stemming from all these events that have occurred in sort of the past year is that clients are increasingly, I think, fearful of arbitration. So I've had some clients come to me and say, I've got an ICDR case, if we show up and we get an American arbitrator, will our nationality be held against us? And I think as a lawyer who's always believed in rule of law and arbitration as a means of resolving international disputes, that's actually something very disheartening to hear, because I think we always, think about philosophical differences or beliefs, I think more in the sphere of investor-state arbitration. But it seems now that I think clients are also worried about whether does the place I come from, does that affect my ability to get a fair hearing? And I think that's something that concerns me, and it's something that with increasing geographical or geopolitical tensions in sort of the Asia Pacific region, this might be something that we might have to deal with.
Great. Thank you all for those excellent presentations. I want to give you all a chance to respond, if you'd like, to any of the perspectives that we heard just now.
I can talk a little bit about the geopolitical tension point, because that's kind of the elephant in the room for us for many reasons. I think there's a number of nuances that are playing out, particularly in Hong Kong at the moment. You've obviously got the geopolitical tension. Oh, mic's not working. I know I really do have to be that close. So in case anyone missed it, I was going to address grab the bull by the horns, as you say, and talk about the geopolitical tension point from the HKISP's perspective. And we're seeing that play out in a number of ways. First of all, it's been the developments in China and Hong Kong over the last couple of years, which obviously have destabilized in some way the perception, at least, of Hong Kong as a safe and reliable place to do arbitration. I do think that the USP of China will continue to play a major role in our caseload. It will probably play an increasing role in our caseload for the next 3 to 5 years or 5 to 10 years, depending on how things play out. But I do think that a lot of the uncertainty is temporary, and a lot of that was, and this was speaking to European and US users to a lesser extent, but a lot of it was also driven by the COVID policies rather than the actual political situation in Hong Kong. And it was quite interesting for us as an institution to observe that, people can come in for an arbitration hearing and stay away from the political side of things. But what was really posing a hurdle for Hong Kong and its attractiveness as an international destination was the fact that you would be locked up in a hotel room for any number of weeks, which has now fortunately been lifted. And I know there is a certain level of misinformation about what that means, but if you come to Hong Kong now, you will not be put in a hotel room. You will have a certain number of restrictions for about 48 hours, but after that you can go about your business with very little interference at all. The second point I'd like to address is obviously the Russian issue right now. And as HKIC in Hong Kong, and I'm sure you would have all seen this in the news, while our chief executive has said that he will comply with UN sanctions, at the moment there are no UN sanctions that affect Hong Kong's ability to deal with SDNs. And we are seeing an increased interest from Russians, SDN and otherwise, particularly and this goes back to Dan's point about their uncertainty about being able to be represented and how the lay of the land is in Hong Kong with respect to not friendliness, but the ability to get a fair hearing or fair trial or fair process, to make it very generic if they come to Hong Kong. Now, obviously, from our perspective, we are at this moment administering arbitrations involving SDNs. There are some certain challenges there that we are basically at the moment dealing with on an ad hoc basis. One of those is payments, obviously. We are in a continuous dialogue with the banks about how we do this, and also obviously with the arbitrators we appoint, because that's something we need to be very upfront about. But we do see that as an area of growth for us. And in terms of opinions about it, for us, it's really about our role as a neutral, independent institution, and also about access to justice for our users. So I thought I'd just take those 2 points and deal with them up front.
Thanks for taking the bull by the horns. Other perspectives from the panel?
So I just wanted to comment on Dan and Sally's point about California as a seat and its challenges. And I agree that there's a lot of potential for California to be a very attractive and popular seat. And that's why we're here. I think that's a testament to that. And California's, I mean, it's there. You can see from the statistics that we both shared that we are getting cases from California, seated in California, governing laws from California. I failed to share the 540 parties that you've seen in one of my slides. Those were actually respondents from California. So there is a lot of space for California to be a prominent seat. And especially because it's a gateway to the Pacific, like they mentioned earlier, there is a huge potential. I think the only, if you look at the CIR's London Centenary Principles or the Safe Seat Principles, California ticks all the boxes. So from legislation to the court stands, pro-arbitration stands, a deep pool of specialist arbitrators here and practitioners. And that's why even for Singapore, our interest is in California. I think if there are any challenges that I can see right now is that the space is just really competitive, especially when parties are very spoiled with choices these days. So there are a number of jurisdictions fighting over to be, the preferred seat. And I guess it's admirable that we're seeing California arbitration associations and system and you guys pushing for this to be a preferred seat.
Thank you. And still, however, SEAC chose New York to open their North America office. And it does seem like we're perennially in their shadow, and that's a big question that I think is on a lot of our minds is how do we emerge from that shadow? You look at a jurisdiction like Miami, which maybe 10, 15 years ago was not as prominent in the international arbitration space as it is now. What did they do right? Can we follow that? Is there a different path for us?
That may be a matter of timing. I think New York got a head start in terms of a local community of experts and professionals who cared, pulling together. But with the efforts that I see with California arbitration, just give it a little time. And I'm sure that we will be hearing more about California. I wanted to also comment on the very important point that Dan mentioned about geopolitical elements. Most of my career has been devoted to transactional lawyering in China, and China has long favored arbitration as a dispute resolution method. So most of the contracts that I was involved in negotiating did have dispute resolution clauses calling for arbitration. Now, many in-house legal departments and law firms are well organized and understand the specifics that we're talking about today in terms of legal framework, arbitration-friendly jurisdiction, some of the things that really count when you look at things in sort of a hard nuts and bolts legal way. But one thing that tends to weigh in at the end of the day and in these negotiations is perception. And sometimes the perception and the reality, doesn't match exactly. but every party wants to be sure that wherever they go, they will get a fair and square opportunity to be treated equally and justly. So that, I think, has weighed in favor of venues like Hong Kong and Singapore, serving as locations that are perceived to be neutral. And that perception of neutrality is always going to be very key when parties ultimately make that decision when they make their contracts. However, even after the choice is made, pragmatism can drive parties to a place like California for their hearings and for their procedures. And I've seen that happen as an arbitrator. I've seen that happen many times, driven by where the witnesses are, where the parties are, where the action is, where the lawyers are. So even if California is not the seat of the arbitration, I think we will see California as a hearing base, as a position for other procedures frequently.
Thanks for that, Sally. All right, I'm sure you all have burning questions that you would like to ask. Is there anyone on Zoom who has their hands up, or anyone in the audience who'd like to ask a question of our panelists? Okay, don't all raise your hands at once. So I'll start with Gary and then Mac, and there's a student in the back there.
I'll get us started at least, and I'm going to go off to the side here. Some of our UC Hastings colleagues told me that I was balding a little in the back, so I'm going to avoid that. So I wanted to follow up on this point about California as an arbitration seat. We heard Sally eloquently speak about how California is the 5th largest economy in the world, soon to be the 4th. And it seems to me the best way to get us going, of course, would be, as Hiro said, why don't we have SAAC and HKIAC open up offices in California? Short of that, but that's not going to happen at least this year, what are some of the other thoughts that the panel has as to really strengthening the relationship between California and Asia? What can we be doing in California to make things better for the institutions in Asia and vice versa?
I'll pick up on Sally's point about perspectives or perceptions at least, because my perception is as one of those institutions in Asia. I'm just thinking about this. I mean, I'm of the view, and I'm very conscious of the fact that there's a person from HKIAC and a person from SEAC sitting here. And there's been a lot of talk, at least in APAC itself, about the competition between the institutions. And I really do share the view that the institutions can do a lot to be working together, because there are so many factors that go into why people pick a particular seat and a particular institution. And there's someone who was in private practice for 15 years. You've seen how that can play out. And of course, there are certain events that are beyond your control that may influence that. But over and all, I think the institutions should be working together. And I do think, and that was raised also in the introductory remarks, there's a proximity between California and APAC that I think would lead to more interest in disputes, and particularly in the technology sector. And I'm very conscious of where we are. And I've seen what I drove past this morning on my way into San Francisco. And I do think that's an area where there are a lot of synergies between the APAC region and this part of the world. And by that, I mean California. And I do think there's perhaps scope, and I'm just thinking off the cuff here based on our own internal discussions about where we see the areas of growth in sectors, that tech is an area where I think institutions could really bring out a specialist working group or something of that nature. And we've been discussing internally at the HKIAC that that's something we could do beyond the borders of the institution itself, and perhaps involving users and to some extent also other institutions. So that's one area I think where that could really strengthen the relationships across the Pacific, so to speak.
I would echo what Mariel just said. And to add to that, I think what we're doing right now is one good example, just really collaborating, introducing each other, the institution in California. There is a lot of space for SIC, HKIC to work with California. We are, for instance, Mariel just mentioned tech space. So we are expanding our pool of arbitrators for tech, and we're looking at Californian lawyers for IP and tech disputes. We can be putting our heads together in certain collaborations with SBAMC FedArb, CalArb, and all the institutions to think of ways of cross-promoting both jurisdictions. And we're open to come here and promote California as well in Asia. So.
Mac, I think you had a question.
Well, first, I was trying to think of the context in which I heard recently that bald is nuclear soup, but I can't remember, so I'll tell you later. But one of the things that jumped out at me on the country of origin for disputes for both organizations is the absence of Japan. And I ask from total ignorance, is that because of lingering cultural feelings or because Japanese businesses structure their contracts in such a way that they don't end up in any of the other major Asian provider organizations? Because I would have expected, given the size of the Japanese economy, it would be somewhere on the list of major countries of source of disputes.
We've seen Japanese parties, but you're right about probably it's not featured much more than other Asian countries. And I think based on my experience, at least when I was going to Japan, is that there is a culture there of more for mediation. So they're less into arbitration or litigation, and that might be the reason. I remember Kobe University would fly us up there to promote arbitration, to introduce arbitral centers to universities, but the take-up wasn't that strong, and it was really because of the culture.
We've identified Japan as an area that we're focusing on for the next 5 years, partly because they did have until very recently a nascent arbitration market. And you can see now how that's changing. And a lot of it's not just the large international firms that have their Tokyo offices that are staffed by a mixture of Japanese and Westerners, but it's also the local Japanese firms. Nishimura and Asahi springs to mind. There's also Anderson and Tonomatsu, and they've both been firms who in recent years have deliberately hired Western arbitration specialists to build their arbitration offering, basically not only to keep it within the home jurisdiction, but also just to increase the prevalence of arbitration and away from a tradition that was, until quite recently, very much based on different principles. And we are actually expanding our Japanese presence on our committees and council as we speak, because we think that is an area to watch in the next few years. Korea is already on our statistics, as you would have seen, but we think there's a lot of potential in the Japanese market, also from where we sit with the Japan-China trade as well.
Is there any tradition in the way that in this country, there was labor arbitration, from at least even before the 30s, some industries, construction ended up. Are there any areas where at least there would be a tradition of arbitration so that it would have within the culture some familiarity as a process?
I don't think I'm familiar enough with Japanese culture to answer that question. I think that, as Adriana said, there was a culture for a very long time generally of not going to arbitration, but in terms of a sector, we haven't gotten that far into our process yet.
Thank you.
We had a question in the back and then Cedric.
Oh, okay. So with Xi Jinping's recent re-election, his third term, how do you think that's going to affect Asian arbitral centers?
That's a wide question too. I think from where Hong Kong stands, one repetitive aspect of this is the support of the central government for Hong Kong as a hub for dispute resolution. And I think there are nuances to that are developing, particularly over the border in the Greater Bay Area, not the Bay Area here, it's the Greater Bay Area. And they are coming up with their own arbitral institutions. And all of that is a bit of a Pandora's box right now because of the border closures. But that's something that we at the HKIAC are definitely watching. And we do think we have the international advantage in a number of ways. But of course, that can be liable to change over the passage of time. So I think from where we stand, the position is still strong and we're grateful for the support, but it's always an evolving piece. So you need to keep on it.
Okay, so follow up to that then. Do you think that there might be an issue where the Belt and Road Initiative, the arbitrations that emerge from that might move over to CTAC just because of it being a mainland Chinese arbitral center?
I don't actually think so. I mean, I've had experience of CTAC arbitrations in private practice, and there are two nuances. There's CTAC onshore in the mainland, and there's CTAC Hong Kong. And there's a couple of very crucial differences between that, particularly with regard to the jurisdiction of the tribunal and the language of the proceedings. I think there is certainly capacity for other institutions to take on Belt and Road disputes, and I'm sure SEAC is taking on quite a few of them. I still would have hesitation, and this is me putting back on my private practice hat, of an international party going to an onshore institution, even one as large as CTAC. And I'm looking around the room at several individuals here that I know, and I'm sure they've got more perspectives to offer on that as well. So I don't think CTAC will take that share of the pie just yet.
The question from the Zoom.
Okay. So I promised Cedric I'd take his question. So why don't you take Cedric's and then we'll go to the Zoom.
This is an observation. From my former perspective as a lawyer, building practices for two firms. And if I'm going to look at Asia the next 10 years, I could sort of see if geopolitical trends continue sort of a gravitation, if there's going to be a China world and a US world. And I think inevitably, the United States and China are going to be in more competition economically and militarily. We heard that from the Secretary of Defense, Lloyd Austin, saying that, he said, Russia is an acute threat, but a declining power. China is right there economically, militarily. So it's going to be, I think US companies are going to slowly separate from China. They can't separate entirely. I mean, Apple's got a huge investments. They're trying to diversify into India and Vietnam, but there are too many smartphones to be manufactured, right now. But I could then see companies choosing, which world am I in? Am I in the Chinese world or am I in the European US world? And China is going to be is the second biggest economy in the world. And so there may be a division of labor, maybe somewhat between Hong Kong and Singapore. And there's a lot of work for both. In terms of Japan, it's always puzzled me that they have the third largest economy. They have very large companies, and they don't have a robust arbitration center. They just don't. We did a program in 2012, that's 10 years ago, in Tokyo. And it was actually Nishimura, Mr. Tezuka-san and I co-moderated a program, all day mock arbitration. And we had 800 people show up in Tokyo. And it was a live feed to Osaka, and there's several hundred people there. And there's a lot of interest, except what happened. There's really not that many Japanese companies who go into arbitration. I mean, they try to work things out. I mean, and if you think about, a national personality, there's some, and this is stereotypes, but trial lawyers think in stereotypes. So if you think about my Japanese clients, they really don't like, you got to train them, and they really don't like conflict, right? They just will avoid conflict. Whereas, my Chinese clients and Korean clients, go at it. I mean, they're more combative, maybe. So I think that's the point that Sally made, that you don't see Japanese clients. They just don't like arbitration. Now, KCAB, there's a limited number of companies in Korea, but they're very large and they're very accustomed to arbitration. So, and they're very loyal. So I think KCAB is going to get some of those, a lot of those, but I think also Singapore and Hong Kong will get some as well. India, that's a very big market, and they're used to common law. You've got all these, Indian lawyers who are very good barristers and solicitors. So I think you will see, more and more Indian arbitrations.
So any reactions from the panel?
I have to say something about
Yeah.
the China comments. I can't just let this, I was listed with the CTAC panel of arbitrators 3 weeks after the Tiananmen event in 1989. The arbitration activity continues in parallel with whatever political things are going on. That doesn't mean that everybody has their heads in the sand and that this doesn't affect people. But there is an arbitration culture that's extremely strong in China. I think the reason why Beijing and Shanghai turned up on the Queen Mary survey, which I thought was very interesting, has to do with the fact that the several arbitration institutes in China receive tens of thousands of cases every year. Now, most of that's domestic, but there's a huge arbitration culture. And the reality is that in negotiations with large state organizations in China, the state organization has quite a bit of leverage to ask that the arbitration be conducted in China if there is a dispute. So I think we're going to continue to see China-based arbitration, and CTAC and the other arbitration institutes that do a heavy load of international cases will continue to do that. They will continue to include international arbitrators and try to put forward an international profile. I think of the words of my mentor, the late Professor Tang Ho-zhi, the grandfather of arbitration in China. He used to say, arbitration venue, it should make no difference. Arbitration should be the same no matter where you do it. Now, there are a lot of people in here who are very knowledgeable and will find nuances in that. But there is a commitment to carry out international arbitration in China, in spite of politics.
Thanks, Sally. So we're almost at the 60-minute mark. I think maybe we can go a little bit longer just to take some questions from the Zoom audience. And then maybe I'd ask those of you who are in person to defer your questions for the reception where you can mingle with the speakers and maybe ask them more informally. So Maddie, do you want to keep the queue?
Yes, so we have Anna Coimbra-Trigo.
Anna.
Hi, go ahead.
Hi, hello. I hope you can hear me.
Yes.
Perfect. Hello, everyone. My name is Anna. I'm a Portuguese lawyer, typically based in Lisbon, also working in international disputes, specifically arbitration as well. Thank you, first and foremost, for such an interesting panel. Unfortunately, I can't be there with you in person. My question touches languages. So specifically, is language a factor that would promote California as a seat? So the other typical seats that as foreigners hear mostly about is New York, which has lawyers from the four corners of the world, as does Washington. Miami has a very strong Latin American card in the sense that Spanish and Portuguese speakers work there as well. Myself, as a Portuguese and Mandarin speaker that grew up in Macau, I'm very interested and very curious on any disputes that involve Latin American and Asian parties. So it would be interesting to see how California scores in this regard. Thank you so much.
Reactions? All right. Thank you, Anna.
Yeah, maybe I'll say a few things. I think all these questions about, what's a better seat, all these are really academic questions. Frankly, we don't know. The only way to really promote California is to get the users to choose it. I mean, that's the plain and simple thing, right? And what's the biggest problem with California? Like, what do you guys think? No one has a guess. To me, it's the distance. It's just too far from a lot of places, right? I actually had a case a couple of years ago that the seat was actually Maui. Can you believe that? And the two parties were an American party on the East Coast and a Korean party. So you can imagine how they got to that. They're like, let's just pick somewhere in the middle that looks fun. It's Maui. And when we all got there, everyone said, this is actually not that close to like either of us. So I think, ultimately we can, kind of try to dissect and talk about things like languages, sort of like the legal framework, whether the courts are supported. But ultimately, it really is the client's decision. So what's important to them, I don't think is really whether, the standard of review or setting aside. I don't think they think about these things. It's more, can I get there? Is it going to be fun if the case settles early? Are there bars? And I think, things like airports are important. So just to plug Singapore a bit, there are actually 3 nonstop flights a day from SFO to Singapore, just in case those. So just to say that. It's just my practical view.
And so we had a double question from Bob Lutz. California is preparing to revise its international UNCTAD-based commercial arbitration law, consistent with the 2006 revisions. How are other countries likely to follow? And then any suggested future reforms is the second question.
What's the first question? I kind of missed it. Sorry.
About the UNCTAD-based international commercial arbitration law revisions. Are other countries likely to follow that similar approach?
So revising their international commercial arbitration law to be in conformity with the model law, 2006. Sounds like Singapore and Hong Kong are already based on this, 2006.
And then there's quite a few iterations since 2006 that if you were revising today, you might take a later version.
Bob's question, I'm not sure.
Sorry, I'm looking at you because you were the mouthpiece. I'm sorry.
Yeah, Bob.
I think it's worth mentioning that California is one of a few states in the country that adopts the UNCTAD model law for its international arbitration. Whereas in Asia, that has been a fundamental approach that's been taken in countries that want to harmonize with international arbitration practice. And certainly Hong Kong and Singapore were among the earliest. In fact, their adoption of the UNCTAD model law was almost in the same year as California, mid-1980s.
And if you think about it, we're coming up on the centenary of the Federal Arbitration Act. And so we really are in a unique class of countries that has a more than 100-year-old, almost 100-year-old arbitration act that hasn't really, on the federal level at least, conformed to international best practices. Next question.
That's all there is on the Zoom.
Right. Any final comments from the panel or from the audience? All right, if no others, thank you so much for joining us today on this panel. There'll be a light reception, so please do help yourself to wine and cheese and other refreshments. Thank you for joining us.